Good afternoon, everyone. This is Mindy Flanagan hosting another episode of Inspiring HR's Uncomplicating HR. I am joined today by the fabulous Sonia Chapin, who is a member of our leadership team, a very senior level HR consultant, and someone who I know, also certified compensation planner, and someone I know based on her past experience and now her, I believe we're hitting 5 years with Inspiring HR sometime soon, can add a lot to this conversation. And we wanted to talk to you today about something that confuses small business owners all the time, and that is, when do I lean on HR versus when do I call legal? With the understanding, of course, that generally speaking, getting HR consultation and opinion is a lot less expensive than involving an attorney. But they have their place, and we thought it would be helpful to have a conversation about where that line is drawn and how we deliver services with sensitivity to that line. So without further ado, Sonia, want to say hello to everyone?
Hi, everyone. It's great to be back for another one of these conversations. I certainly enjoy it, and interested to. Well, it'll be great to dive into this today because it's a hard line to navigate.
And it's interesting when myself and Valerie Juarez, for the most part, engage in sales meetings or we're talking to prospects about who are interested in our services. This even comes up sometimes during the sales process. Like, how do you honor that? How do you know? And sometimes it comes up because, honestly, in our service agreement, it says we are not providing legal expertise. I think we even have that in our signature line on our emails.
Yes, we do.
Because you really do need to understand there are people with HR experience who can weigh in on lots of things, but HR is not in a position to say, yes, this will hold up in a court of law. Or, yes, I can absolutely and definitively give you a legal opinion on this thing. And a good HR person knows not to do that. And sometimes we're pushed, honestly, because some clients would rather spend $150 an hour than upwards of $500 an hour, which is what some attorneys charge, and probably rightfully so, based on how they practice, what firm they're a part of, and what level of expertise they bring to the table. So I'm going to just toss a general question to you, and we're just going to let this conversation evolve naturally. Where do you recall this most recently showing up? Give everybody some examples of that line between where HR ends and the need for legal expertise begins.
So I liken this to a lot of times what I do as an HR professional is to help train managers in terms of identifying when they need to get HR involved in typical operations situations.
So you even want to start there. Like, before you're even dividing between HR versus legal, let's talk about what triggers you to call HR.
Right. So, but because it's very much the same line, right? And it's very much about knowing what your expertise is as an operations manager and as an HR consultant or practitioner to say, I'm going to go up to this line, and then once we start, I'm very comfortable up to here, this is my expertise, and once we get past that, I need to get HR involved. And so examples of that might be if an operations manager hears for 2 or 3 times an employee make a passing comment about a disability. Oh, that's just my ADHD, in passing. If that happens one time, maybe not, it's a passing comment. If it happens more than once, that's a sign to the manager to kind of be like, well, I'm going to at least ask my HR person about this and see if there's anything else that I need to do. The same types of situations I have encountered with regards to things that I have been involved in and advised clients on. A lot of times I will be able to draft and provide fact intensive drafts for a client. But when
you talk about something like there's an EEOC charge statement and we need to gather information to ready that for the position statement, right, that the attorney would write.
Right, exactly. Yeah. So the attorney, so a lot of times, since I've supported the situation and I've supported the client, I have a lot of facts that I can share with, and I can document those facts in like a position statement or something like that. So I can oftentimes draft those types of documents and then hand them off, So it's important to be organized enough to give the attorney enough time to then be able to read it to clarify facts. There's always going to be additional information that they ask for. And so those types of things it's a good example of a good use of HR when they're closer to the situation and they're able to provide a little bit more detail around the situation. Another example might be an agreement. So, for example, a company...
Oh, an employment agreement.
Yes.
Yeah, okay, let's open up this conversation.
So a lot of times, especially with small businesses, they get as they're getting started, it's, their friend's uncle or someone like that who's come on board and is helping them out. And as they start to scale and grow, they move away from either handshake deals in terms of compensation, or potentially, an agreement that was provided to them by their business attorney to support their first couple of hires. And at that point, it's one of the things that we value here at Inspiring HR is simplicity. And those types of agreements can get complicated very quickly, especially as you're trying to scale.
Or unknowingly supersede employment at will, and you didn't even realize it.
Exactly.
And you don't want to give up rights under employment at will unless absolutely necessary.
Right.
Yeah.
So when you're starting to employ someone who is external to the organization, you don't need the complexity of an employment agreement. What you do need is a good offer letter that provides for things like, what is the payroll period? What is the rate of pay? Is it hourly? Is it salary? And preserves that at will, as well as puts any kind of stipulations on the offer that, like background checks that need to be completed after an offer is actually provided to the employee or potential employee. So those types of things can be covered with a really good offer letter. And we don't need to have the complexity and the added complexity and potentially giving up some of the rights that we have as employers by preserving things like that.
A legally enforceable employment agreement. And I'm talking about, I ran this by an employment law attorney, and I absolutely need this employment agreement for XYZ justified reasons. In your opinion, what are those XYZ justified reasons? What are the conditions of that job that make it unique to, we'll call it, the general hiring population that would dictate the need? And the reason I ask this is understand that if you have the more employment agreements you have per position, the more legal expense you're going to have year in and year out, because they have to be reviewed more often.
Right.
Because they've often got guarantees in them, and there are state laws that may negate the enforceability of certain provisions of that agreement from when it's drafted to when you still need it to be legally binding. So what are the conditions that create the need for employment agreements?
So if this is truly a key employee of the organization, that could be a case where you have a more structured employment agreement in place. Those types of things that would lead into that type of an analysis might be if you're giving away any type of equity in the company, if there's any type of deferred compensation other than an annual bonus, if there's anything...
Which, by the way, deferred is considered guaranteed compensation.
Exactly,
right?
yes.
So, again, guarantees.
Right.
Not employment at will, guarantees.
Exactly.
Yeah.
So any type of person, again, employment at will, right, says that essentially either the employee or the employer can separate the employment agreement at any time with any good reason, right? So it should be, so we should have a reason.
As long as it's not an unlawful reason.
Right. As long as it's not unlawful. So, or it's a pretext. So that is what at will means. And so if you want to preserve that in any instance that you're hiring a new employee to your organization, if there are reasons, like I said, if this person is receiving any type of equity award, if they are having any type of long-term compensation outside of, something along the lines of an annual bonus, those are all reasons that the employment agreement should be in place. But that is primarily when we would recommend it if it's truly a key employee, and if as a business owner you can picture that this employee is not going to be replaced easily. that's another reason to potentially have an agreement in place.
Yeah, what we saw that was alarming just a few weeks ago is where we disagreed with a business attorney who didn't specialize in employment law, that there were appointment agreements being put in place for a pool of employees, some of which were below the wage threshold for non-competes to be able to apply, right? So there's like an employment agreement with non-compete language in it, which, some states have outlawed completely.
Mm-hmm.
In this case, non-competes were allowed in this state, but only at a certain income level. Yet we still wanted to put an employment agreement for mid-level employees to self-identify when they read it, whether the non-compete language applied to them or not. And it's like this 18-page heavy lift with all kinds of legal complexities. For us, as an example, an equivalent would be a systems analyst. Like, I'm just thinking, this is just not necessary. I'm not sure why a 2-page offer of employment and sign a confidentiality and non-disclosure agreement on your first day of work wouldn't be sufficient.
Right.
So,
yes.
And that's where I really struggle with employment agreements, is just understanding who they really apply to. Like that COO that you're guaranteeing employment for a 5-year period of time, and if it doesn't work out for whatever reason, you're still going to pay them out 6 months worth of pay. Like, these are all kinds of guarantees.
Right. Yes.
And so that's where you start to deviate, of course, from the offer letter.
Absolutely. So, and if you think about it from the employee perspective as well, that's a little daunting, right? Like, to receive an 18-page,
completely intimidating.
If you want to work here, you have to sign this 18-page agreement. So that again goes back to our value of simplify. Wherever possible, simplify. So what are some other times that you might want to get legal involved? I have a few.
Yeah. So I'm searching there's tons, but it's almost like, for me, I've been doing this for so long that my gut almost kicks me.
Right.
Like, in the middle of the conversation, I hear something and I'm like, oh yeah, I can't weigh in on
nope.
that.
Okay. Right. Yeah. Yes. Yeah. So there are a couple of times when I've had those.
Or sometimes, sorry to interrupt, I say, I have an opinion on this, but it's not a legal opinion, and you need a legal opinion.
Right.
So why don't we get you one?
Yes. Yeah. Exactly. So there have been times, I'm trying to think of times when I have recommended to clients to just go directly to legal counsel if there are truly serious allegations in play. HR professionals are great at being an independent third party. We can do investigations. But if there are serious allegations in play, or if there are executives involved in those allegations, that's often a time when you might go initially to an attorney. Another time that I have passed off a client and initially write directly to an attorney is if there's a really quick turnaround. A lot of times this will come with audits that have happened at various state levels. There are not a ton of federal audits that are happening right now, but the state agencies are still very active. And a lot of times, especially if in my initial discussion with the business owner, they say that they have, concerns, or they identify that there are instances where I can see moving down the road in this audit that it's going to come into greater scrutiny, I will almost immediately recommend legal representation at the outset. And then the last time that I can think about is if another attorney is already involved.
Oh, right.
So if there are...
You got to bring, you have to level the playing field there. This is what I say,
yes.
to mitigate the risk.
Absolutely. Yeah. So sometimes we've received, letters from previous employees or something like that. And if that is
I am represented by... Right. Yes.
Yeah. Now we have seen an uprising, a lot of AI generated letters directly from the employee. That's something that your HR person can help with. Sure. But if there is another attorney involved, then absolutely, that's a good way of putting it. You need to have one involved on your end as well.
I just thought of a recent one now that I was racking my brain on what's sitting in my inbox for my attention. We have a client who unfortunately has lost some funding. They're planning out their runway, and in their proactive efforts to figure out who might get displaced by when, and they're distributed across 5 states. they're talking severance agreements, and everybody goes to, if you're not trained on this stuff, your reasonable person standard goes to, I'll give you 6 months of pay if you sign this document that says you won't sue us. And this is, for me, there is some HR best practices that can be weighed into this to draft that severance agreement, but in no way, shape, or form would I put a severance agreement with any kind of release and liability in it that you want to be enforceable. Right. There's no way I would present that to an about to be laid off or separated employee without legal review and endorsement of its enforceability. Because every state, and you could correct me if I'm wrong on this because you're a little bit more current, every state has different right to rescind laws, laws on how long you have to give people a time to review it. And generally speaking, that the language you choose around "you won't sue me," you have to be careful with that, because often that's personal or civil suit. No agreement is going to be enforceable where it takes employee rights away or ex-employee rights away to go and file a complaint with a state or a federal agency. Yes. Anything I forgot on that front other than, so an attorney should review the severance agreement?
They should definitely review the agreement. In that situation that you mentioned, this is where HR can be really helpful, because under direction from the attorney, we can modify the approved language. As an example, if someone's over 40, they have 21 days to review the document. Whereas in normal instances, or with folks under 40 years old, you can generally give about 7 days to review the document. So those are types of things where HR folks can definitely assist with carrying out under the direction of an attorney.
And to close just on the math on that seems a little bit more appealing to me as somebody who makes decisions about how the money gets spent at Inspiring HR. Pay, if the total, let's just say the total project is 5 hours from start to finish, I'm pay HR 3 hours to get me most of the way there at $150 an hour about, and then I'm gonna write a check to legal probably to the tune of $450 to $500 an hour to finish it out. To me, that is a lot more appealing than writing $450 to $500 an hour for the full 5 hours. So, to your point, even in terms of being economical about it, there's an add value to involve both parties and make sure they're working together in the same direction.
Yes, so absolutely.
Yeah. Awesome. I hope this was a good little exercise on demonstrating that Inspiring HR is sensitive to that line between HR versus legal, but we certainly appreciate a lot of the legal partners we've worked with along the years, particularly the ones that are specifically trained in employment law and certified in certain states, because there are a lot of state variances in terms of what is and is not enforceable across these agreements. So multi-state expertise is certainly something to consider as well. Thank you very much for joining us for Uncomplicating HR. Sonia, thank you again for joining me. We wish everyone well, and if you like what you're watching, feel free to subscribe to our YouTube channel. And if you want to subscribe to any of the information we distribute automatically, such as our Empowered newsletter, you can sign up for that at our website by clicking the subscribe button that you will find on the homepage. Thanks so much, everyone. Have a great day. Bye-bye.